Hello and welcome to the State Constitutions Lab, and to this recording of our very first event, a conversation about the state of the field of state constitutional studies. This event was recorded on October 24th, 2024, and runs about an hour. This event was held online and in person at the Brennan Center for Justice in New York City. It was organized and moderated by me, Brian Murphy, Associate Professor of History at Rutgers University, Newark, and a Stephen M. Poland Fellow at the Brennan Center for Justice. Before we get started, let me just say a word about the State Constitutions Lab. This is a new initiative to advance interdisciplinary and comparative research and new methodological approaches to the study and understanding of American state constitutions and their role in the development of democracy and self-government in the United States. As scholars and legal practitioners show newfound attention to the rights, provisions, and unique histories of these governing documents, we welcome a community of historians, political scientists, and legal scholars and practitioners interested in engaging historically informed research on how state constitutions have been written, amended, and used to legislate and litigate from the founding era to the present. Supported by the Brennan Center for Justice, we'll be holding workshops throughout the academic year. We look forward to soliciting contributions for an edited essay collection exploring the importance of state constitutions to mark the 250th anniversary of independence. To learn more about this initiative, visit our website at stateconstitutionslab.org. You'll be able to join our mailing list, see our call for papers and proposals, learn about our future projects, and meet the members of our research team. After you visit our site, check out the Quill Project at quillproject.net to learn more about their cutting-edge approach to studying how constitutional conventions write, negotiate, and adopt constitutional text. Okay, with that housekeeping out of the way, let me introduce our panel for today. Our guests are the Honorable Jeffrey Sutton, Chief Judge of the U.S. Court of Appeals for the Sixth Circuit, and the author of Who Decides? States as Laboratories of Constitutional Experimentation, published by Oxford in 2021, and 51 Imperfect Solutions, States and the Making of American Constitutional Law, published by Oxford in 2018. The former Solicitor General of Ohio and Supreme Court clerk to Justices Lewis, Powell, and Antonin Scalia, Judge Sutton was appointed to the U.S. Court of Appeals in 2003 and is a prolific lecturer and writer on federalism and state constitutional law. Jane Manners is a legal historian and assistant professor of law at Temple University. Professor Manners is currently working on a project on officer accountability in the 19th century, and she's published related articles in the Columbia Law Review as well as the Fordham Law Review. Jessica Roney is an associate professor of history at Temple University, and she's the director of the program in Early American Economy and Society at the Library Company of Philadelphia. Professor Roney is currently at work on a book project titled The Revolution Out of Bounds, arguing that colonization and struggles over expansion shaped American constitutional development as citizenship, sovereignty, democracy, union, and the meaning of what it meant to be a republic were critically shaped during the American Revolution. She's the author of Governed by a Spirit of Opposition, The Origins of American Political Practice in Colonial Philadelphia, that was published by Hopkins in 2014, and most recently she wrote an article in the Journal of American History about state formation and the implications of a 1778 treaty between the U.S. and the Lenape Delaware Nation. Robinson Woodward Burns is Associate Professor of Political Science at Howard University and the author of Hidden Laws, How State Constitutions Stabilize American Politics, published by Yale in 2021. Using datasets and historical case studies, his book argues that high barriers to national constitutional change have encouraged reformers to instead seek state constitutional revisions, where they address national controversies over economic and labor regulations and voting, civil, and gender rights. He is currently working on a second book on state constitutionalism and voting rights. Judge Sutton started this conversation off from his chambers in Columbus, Ohio, reviewing the state of the field. Jane Manners and Jessica Roney joined us both from Philadelphia in their respective offices. And Robinson Woodward Burns and I were both in New York in the Brennan Center offices, joined by some staff members from the center. Before our recording picks up with Judge Sutton joining us from his chambers, I should note that all of our participants joined us voluntarily and donated their time, and there is no pending or anticipated litigation related to this conversation. Let's join Judge Sutton.
Partly through the eyes of a scholar, partly through the eyes of a judge, even though as a federal judge, we rarely get these issues. I guess the first thing I wanted to address is the why now. I've not done a study on this, but I'm pretty confident I'm right about what I'm about to say. That in the last 5 years, the Wall Street Journal and the New York Times, probably our two leading national papers, have written more articles about state courts and state constitutions than they have in their entire histories, which are longer than 100 years. These are profit-making entities. Why is it that they think their readers want to hear so much about state courts and state constitutions? Well, the short answer is Dobbs, the abortion case, and Rucho, the gerrymandering case. Those two really dynamic cases, both overruling prior U.S. Supreme Court precedents, have thrown issues about abortion and gerrymandering back in state legislatures, state constitutional amendment settings, and then, of course, state courts. So that's one feature of this, but I think it's a little misleading to say this is a function just of Dobbs and Rucho. The reality is that for several decades, you've had similar stories going on, just not with equally salient issues. In school funding, the post-Rodriguez story, where the U.S. Supreme Court put up a big red stop sign, saw one state court after another addressing these issues. The same thing with Smith, the 1990 free exercise decision, which to some under-enforced free exercise. Lots of state courts and state legislatures and even Congress got in the mix. Something similar has happened with Kelo, the property rights case. So I would say Dobbs and Rucho have a lot to do with the attention being given to this topic, but I would also say this has been going on, at least since Justice Brennan's article in 1977. But there's no doubt that Dobbs and Rucho have really made this more salient. The second context point is, this was not really an option for most of American history. Some people wonder why, lawyers, courts hadn't been paying attention to this second state constitutional shot all these years. And the reality is that really until the Warren Court, most individual rights litigation proceeded in separate spheres. If someone didn't like a federal law, they went to federal court. If they didn't like a state law, state executive branch action, they went to state court and used state constitutions. And with the Warren Court's incorporation of almost all of the Bill of Rights, they're almost all incorporated at this point, you really do have a situation where if you lose a Fourth Amendment search and seizure case in federal court under the Fourth Amendment, it makes a lot of sense to consider the state option with the counterpart search and seizure guarantee that's in one form or another in every state constitution. The other feature of today is the U.S. Supreme Court, of course, is not the Warren Court. The Roberts Court is less likely to innovate new federal constitutional claims. And as the Rucho and Dobbs stories show, they're even willing to overrule long recognized federal claims. So that also has put more of a spotlight on the state courts and state constitutions than have been true in the past. I think a third thing going on that you don't want to lose sight of is both the vice and the virtue of state constitutions. For me, the big virtue is it's got something for everybody. It's not inherently right, left, liberal, conservative, Democrat, Republican. As my cataloging of cases showed, there are lots of situations where, for one reason or another, the U.S. Constitution does not protect a given right. and the states have filled the gap. And that's been true in conservative settings. Think Kelo, think Smith, free exercise. It's been true in so-called progressive settings. See Rucho, see Dobbs, see Leon, the good faith decision, where half the states now have rejected the Leon good faith exception to the exclusionary rules. So there's something for everybody. I consider that a virtue. I suppose some people consider it a vice, that one day a state court, state constitutional claim helps you, the next it hurts you. The other way in which it's quite neutral and therefore potentially appealing to a very large group of people is the fact that it's relevant to all methods of federal constitutional interpretation. So, if you take originalism seriously, and if you're a good lawyer, you're going to do whatever you can to win a case. And if the original fixed meaning helps you, you should use it for a liberal or conservative outcome. You obviously can't do originalism without paying attention to the source of these federal guarantees. And as very few Americans appreciate, everything in the first 8 amendments to the Bill of Rights, the 14th Amendment, language, due process, equal protection, all of this originated elsewhere. That elsewhere was state constitutions. And so prior histories of those state guarantees, prior interpretations of those state guarantees are highly relevant to federal interpreters of the federal guarantees. Well, for the pragmatists, think Judge Posner or Justice Breyer, their goal is to take a difficult to understand, maybe even indeterminate guarantee and at least make sure it doesn't make things worse. So that's the pragmatic orientation. What better way to figure out whether an interpretation might work at the federal level than to see how that interpretation is played out at the state level? Think of that as the Brandeis approach, ground up development of new ideas, a market of new ideas. The best ones succeed. Maybe there's 2 or 3 camps. If a winning insight emerges, you nationalize at the federal level. If not, maybe you leave it at 2 or 3 approaches. But again, the federal judge, who's a pragmatist, is going to be interested in those experiments. The third possibility is the so-called living constitutionalist, evolving meaning, more informal method of interpretation. Think Justice Ginsburg. It's a caricature of living constitutionalists to say they just look in the mirror and see staring back at them their version of the federal Constitution. No, the more fair way of putting it is they will say that in the context of some highly general guarantees, think of the word unreasonable in the 4th Amendment, cruel and unusual in the 8th Amendment, maybe even due process in a substantive sense. They're going to say those types of general guarantees can evolve to account for shifting norms in society. Well, what better place to look for evidence of shifting norms that's objective as opposed to subjective than to look at what states are doing, whether state legislatures, state court decisions, state constitutional amendments. So I think these features that federal interpreters all benefit from paying attention to state constitutions, the fact that state constitutional independent interpretations can potentially benefit every political stripe has, I think, really increased the significance and appeal of them. The last point, and this I could go on forever, but I'll just make a few points to get the conversation going, or at least I hope to be of some interest, is kind of thinking through why it is a state court would chart its own path in construing identical language in a state constitution or similar language in a state constitution. So we're talking about a situation where the U.S. Supreme Court has put up a big red stop sign. Think Dobbs, think Rucho, Smith, Kelo, Rodriguez, Leon. Why is it that a state court construing its own constitution might come to a different interpretation? Well, there's a lot there, and I just want to highlight a few points that frankly took me a long time to appreciate and that I'd like to at least mention to this group. The one that I probably find the most appealing because it applies the most often is the reality that it will be the case roughly half the time that the method of interpretation at the federal level for a given precedent will differ from the prevailing method of constitutional interpretation in a given state court. So let's take my state, Ohio. From outsiders' perspective, people would say it's a 4-3 court with the 4 in the majority, more along the lines of formal interpretation, fixed meaning, think Scalia. Well, if that's the case in the Ohio Supreme Court, I'm positing for the sake of argument it is. If that's the case in another state court, why half the time the federal precedent is going to be at a different register. It's going to be a different method of constitutional interpretation. So back to Scalia-Ginsburg, if the federal precedent is a Ginsburg informal method of interpretation, living constitutionalists, not fixed meaning, that not only that shouldn't hold sway to originalists at the state level, it actually should be presumptively wrong for originalists at the state level. Now you can flip it and you imagine a state court. Let's hypothesize the California Supreme Court, and let's hypothesize that their prevailing approach to constitutional interpretation is more likely to be informal, more likely to be the Ginsburg model. Well, in that setting, if the federal precedent is fixed meaning formal, it's presumptively wrong by their lights in construing similar or even identical language in the California Constitution. The other thing that, as a federal judge, I'm fairly sensitive to, I happen to have tremendous respect for my colleagues throughout all 1,000 federal judges, but it's not obvious to me that we're always right. And just speaking of my own cases, when I look at tiers of review, equal protection cases, I really find myself struggling sometimes with whether tiers of review is panned out as a neutral, principled way to discern the meaning of the Equal Protection Clause. Now, whether I'm right or wrong about that, I think we can all agree there's room for criticizing tiers of review. And if that's the case, it's very strange that a state court would casually adopt that doctrine in dealing with an equal protection case. They might instead go back to their class legislation approach, which prevailed in the 19th century. It's one reason I've written in one of my books, I think the state courts didn't go down the road of Buck versus Bell and did a much better job in handling eugenics cases and the problem of involuntary sterilization. So sometimes the doctrines failed. The last point I'll make, because a lot of people gravitate to this point pretty quickly in comparing federal and state courts, is the reality that 90% of state court judges go back to the ballot box in one way or another. Retention elections, partisan, nonpartisan elections, and that 90%, it's not 90% of the states, it's 90% of the total number of judges. And I think the thinking is that, or the fear is that elected judges are less likely to be counter-majoritarian and therefore less willing to break ranks with a federal interpretation of similar identical language in a state guarantee. I just think this just shows the tremendous lack of imagination of the lawyers at the state level litigating these cases. I should have thought elections cut precisely the opposite way. I can't imagine, as someone running for state retention or state office as an elector, as a judge or a legislator or as a governor, in getting the question, Jeff, what do you do with hard cases? And saying, oh yeah, I always ask myself the same question. What would the U.S. Supreme Court do? That's just not a winning answer in any state in the country at any point in American history. The people of every state take tremendous pride in their ability to solve local problems. And this gets to my last point, and I'll end it here. The state courts get to do something that we federal judges cannot do. They can customize the meaning of general language to account for unique historical experiences, unique culture, unique norms, in different parts of this incredibly vast country. And elections allow that to play out. They allow the judge from Oklahoma or Wyoming or California to say, we got a California way of handling this type of thing. And they can say that with pride, and it will resonate with the people in that state, including in the next election. So if anything, elections should cut the other way. But I fear scholars, lawyers, etc., have not been sufficiently imaginative in seeing the upsides of elections. So, Brian, I could go on forever, but I hope I've said enough provocative things to get the conversation going.
Yeah, thank you so much. We'll turn to Robinson.
Sure. First, thank you, Judge Sutton, for those excellent comments. I will note that you paid me a really great compliment, but one which is not due. I'm not actually an historian, I'm a political scientist. And so I'll try to approach this as would a political scientist, which is to say I'll try to give you all a little bit of a causal story as to why the states serve the kinds of roles they do in American constitutionalism, and I'll do this briefly. And I hope by giving that causal story, I can maybe balance the panel a little bit between our perspectives, between that of a judge, that of some historians, and that of a political scientist. So Judge Sutton is absolutely right that we're in this period in which American state constitutionalism is once again salient to the public, primarily perhaps because of Dobbs. Following Dobbs in 2022, a number of states passed state constitutional amendments affirming or recognizing a right to reproductive care, and we have a number of similar ballot measures on coming up in state elections week after next. These ballot measures are partly why the public is increasingly interested in American state constitutionalism. There is then maybe this lesson that we might take that the state constitutions and the states generally act as an alternate venue for realizing policy. If the federal courts are closed, for example, to appeals for reproductive rights, we might instead circumvent the federal courts by looking to the state courts or by reforming the state constitutions by initiative or by amendment, legislatively referred amendment. And that initiative process is especially attractive because, again, there are 18 or 19 states that allow the initiative, and that depends on whether Mississippi's citizen-initiated constitutional amendment process is still operative. And then even outside of that, there's this idea that state constitutional amendments, when initiated by the legislature, also have this kind of majoritarian democratic function, since unlike the federal amendment process, which requires supermajorities for passage, in most states you need a simple majority in the legislature and then a simple majority of voters to approve or ratify the amendment. So it seems like the states might be this much more democratic way to circumvent courts, especially counter-majoritarian courts that might be hostile to, for example, protecting reproductive rights or voting rights. And for this reason, progressives are again rediscovering the states. We have sort of this long tradition of thinking of states' rights the way they were perceived in the mid-20th century as being a kind of reactionary approach to politics, and now progressives are attempting to rediscover the states. So I'll give you all a reason why I think that might be wise. I'll tell you all why I think that may be wrong, and then I'll hand off. So history does give us some examples of cases where the states really did serve as a venue for addressing policy goals that might not have been available or realized at the federal level. I'll give you all two examples of this. First is the Equal Rights Amendment. Y'all may know that the Equal Rights Amendment, which would have forbade discrimination on the basis of sex under the federal constitution, came very close to ratification. 35 out of 38 states ratified within the initial deadline imposed by Congress, but it fell 3 states short and kind of ended up in a legal limbo, which I won't get too much into. In the late 1970s into the early 1980s, as advocates of the Equal Rights Amendment realized that the federal amendment was unlikely to reach ratification, they instead began pushing for state equal rights amendments. There were, at the state level, some prior equal rights amendments, as well as equal protection clauses, which state courts had interpreted to forbid sex discrimination under law. And in the same period, especially in the late 70s, early 80s, as the Equal Rights Amendment at the federal level began to fail, we see almost 24 states passing complementary equal rights amendments, such that if you see that you're blocked, say, in Congress in trying to ratify a federal amendment, or in the states trying to ratify an amendment, you might look instead to the state constitutions to pass a similar kind of amendment. And as Justice Brennan's article showed, and as Judge Sutton's books have shown, state constitutional amendments often exceed that minimum federal rights minimum protections. We might also think about the poll tax. That's kind of an opposite story. In the case of the ERA, a federal amendment fails and we move to the states. In the case of poll tax repeal, we actually start at the state level before moving to the federal level. So states gradually repealed the poll tax, this racially sort of biased tax, which required that you pay a tax of $1 or $2 when going to the polls. States repealed that before we see federal action. North Carolina, for example, repeals it in 1920 because it disenfranchises primarily white Appalachian farmers. Huey Long, governor of Louisiana, pushes for repeal about 10 years later. Georgia, Florida, within a few years of that. By 1953, there are only 3 ex-Confederate states that actually maintain a constitutional poll tax. It still takes another decade for the federal tax to get repealed. And one of the reasons that you see in the federal Constitution, this anti-poll tax amendment, the 24th Amendment, is because members of Congress recognize they're just effectively affirming existing state constitutional law. So these 2 cases, the poll tax and the ERA, would tell us when you don't succeed at the federal level initially, you might then instead look to the states. And that seems to be the lesson in this post-Dobbs era. I want to conclude by saying why this process might no longer work, why the states may not serve this venting mechanism for resolving national constitutional issues. States are simply less majoritarian than they used to be. Increasingly, we see through gerrymandering, voter suppression, and on rare cases, things that look more like kind of election subversion or unconventional modes of election administration. We see state legislators are increasingly able to entrench their seats against voters. There are 2 sorts of things that are happening as a result. Sometimes a party that entrenches itself in the state legislature, especially through gerrymandering will inflate the number of seats it wins. So if a party gets 55% of the statewide popular vote, it might win 65% of the seats. In swing states, we see what are called counter-majoritarian legislatures, as Miriam Sefter has pointed out, in which a party can lose the statewide popular vote, but nonetheless maintain a majority. So in 2018, Wisconsin Republicans won only 45% of the popular vote, but took 63% of state legislative seats. What this means is that state legislatures are increasingly insulated to and resistant to popular opinion. We see incumbency increasing at the state legislative level. And so in most states, the initiative process, which begins the amendment process, which begins not through citizen initiative, but through legislatively referred constitutional amendment, that may be closing as legislators are increasingly insulated from public opinion. What this means, this polarization at the state level, split into red states and blue states, and increasing sclerosis within states as parties entrench themselves through tools like gerrymandering and vote suppression, is that the states may be as state legislators, as public policymakers, and as constitutional lawmakers may be increasingly resistant to public opinion, such that the states may not really be this sort of venue for public policy change and constitutional change that they have been in the past.
Thanks so much. Jess Roney, it strikes me that historians just come at this from a very different angle.
And agree with you. I was thinking about the list that Judge Sutton shared with us of reasons to turn to constitutions right now. And for me, one of the reasons that comes up is historical. It's that we are at the 250th anniversary of the American Revolution. We're in the midst right now of the First Continental Congress was meeting 250 years ago right now. And we're just going to keep seeing this going forward. The celebration of independence and various battles, ultimately independence, and then when we get to 2037, we'll be getting to the anniversary of the federal Constitution. So we're in the midst of this moment where historians are thinking about anniversaries, and I think there's a conjunction between the desire to think about the history of the country and the anniversaries that we're studying. and thinking about the origin story of these constitutions. And I think this is why I've been asked to be part of this conversation. I'm the director of the program of Early American Economy and Society at the Library Company of Philadelphia. Brief moment, the Library Company of Philadelphia was founded by Benjamin Franklin nearly 300 years ago and is still in operation with its original texts that were first collected all that time ago, and is a major research library for early American history, or just, I should say, American history. We are planning a conference that's going to be called Constitutions Everywhere, and we're planning it to take place in 2027. And I think this, the conference that we're organizing, I think sort of gestures at some of the ways that historians are thinking about state constitutions. So because I think there's a lot of interest and attention by historians on the moment of the federal constitution, I wanted to organize an event that would be around constitutions other than the federal constitution. So I'm actually really interested in the Articles of Confederation because I'm an historian. I'm interested in the paths not taken or the paths that didn't persist, like the Articles of Confederation. We're interested in the state constitutions, including the states that you may not have heard of, states that were attempted along the way but failed for whatever reason. So one component of the conference is about states, constitutions as enacting states, as mechanisms of creating states, and about, in the moment of the founding, the debates about who has the power to write a constitution. Obviously, there were 13 historically rooted colonies that created states that had the same basic geographic limits as those colonies had before them. But what to do about all the states that would come after? Who has the power to create those constitutions? Do they have to ask permission? Whose permission? If this is a system built on self-determination as enshrined in documents like the Declaration of Independence, if people feel like the social compact has been broken and they're too far, especially too far west and across the Appalachian Mountains, which is a very important geographical boundary at this time period, can they invoke the principles of the Declaration to say, you cannot govern us, you're too far away, the social contract between us is broken, and we have to govern ourselves in ways in ways that echo the Declaration itself. So there's a failed state called Franklin, where that is literally the argument they're making. They pull one of the delegates at their constitutional convention in 1784, pulls a copy of the Declaration out, and he waves it around and he says, the principles in this document apply to us as well, except it's North Carolina that they want to declare independence from, not George III. So anyway, one part of our conference then is around that idea. Who gets to make a state and how is that organized? What does state making mean? The second, there are three components to our conference. The second component is constitutionalism in everyday life, the way that Americans really imbibe the idea that constitutional thought and constitutional process matters to us on a daily basis. So involuntary associations, in various forms of civic private organization, or I shouldn't say private, but not necessarily through the state, but under their own auspices. As they are creating their own organizations, fire companies, militias, even corporations, like creating the Erie Canal, the way that they are invoking the idea of constitutional process, both internally as they're writing their own documents that are like constitutions, and then externally as they are applying to state legislatures, state constitutions, state courts, and trying to manage expectations there. And then the third leg of the conference is, or sort of aspect of it, is constitutionalism that might not be recognized as such under Anglo-American jurisprudence. So here, for example, thinking about indigenous forms of constitution writing that might not look like it from the state standpoint of white settlers who are looking out from outside at those polities, but the way that constitutionalism might be operating in ways not always fully registered otherwise. So I think as historians are thinking about state constitutions, at least historians like myself who are really rooted in the 18th century, the founding moments and decades around the founding, I think some of the central questions that are coming up for us resonate from the current political climate that you're describing, but I think also are really called into being by the investment politically and judicially we have put on that moment itself. And so trying to provide the context for understanding the way that local polities and smaller entities even than state levels are invoking constitutional thought and evolving it over time. So I can answer questions, but that's sort of the perspective I'm bringing to it as an early American scholar.
Yeah, thank you for that. You know, it's such an interesting, it's interesting that you mention the idea of how, of sort of newfound interest in how a lot of these documents are written. And, you know, Nicholas Cole, who was going to join us here today, directs a project at Pembroke College, Oxford, called the Quill Project, that takes all the records of conventions, and instead of just doing a straight up digitization project, it involves making them more searchable and showing sort of taking giving people a chance to take apart. If you've ever worked through the records of the Federal Convention, you'll know this. It's a challenging experience for a lot of reasons, and one of them is that proposals get brought up and dropped and postponed all the time, and it's very difficult to tell at any given moment exactly which text has been agreed to, what's being considered, what the effects would be if it were adopted or rejected at that moment by the convention, and how what that ends up looking like in the final version itself. And so the Quill is this, Quill's a tool, I think, and this is part of, I think, what makes this field, really poised for some dynamism now, is that there are tools available that are in the process of becoming available that are really different than what our forebears had to work with when when Willie Paul Adams was looking at state constitutions, or when Gordon Wood was looking at them at convention debates and trying to discern what that meant for what the founding of the United States looked like. We've got all these other ways that we could potentially look at convention records that would be, in some ways, I think inspired by people trying to look for ways to hold originalists' feet to the fire in terms of methodology, and then if we're going to commit to look at context and historicizing constitutional text, at the very least we need to go deep into convention records. But beyond that, I think it's suggestive of different ways to approach interpretations of state constitutions and localize and specify what different contexts look like, right? Like there's I'm looking at I've been looking at we were talking before about our writing projects that are, it's October for anyone who watched this later on. And so it's a difficult moment in the academic calendar because all the midterms have to be graded and all this work has to be done. So all the writing projects go into sort of stasis, unless you're fanatical about getting your 1,000 words a day in. And I've been working on something with the Judiciary Acts and the Chase impeachment. And it's interesting to look at how people's experiences of serving on the federal bench in early America are shaped by whether or not they had been on a state bench beforehand, or whether or not they'd participated in the federal convention or in a state convention. And how they will then look at the legitimacy or lack thereof of their state constitutions, depending on whether or not the process for writing that state constitution measured up to what the federal convention does. So I keep finding in New Jersey, people keep complaining that New Jersey doesn't have a real state constitution because it wasn't written by a convention. It was just written by the state legislature. It was written before, and it was actually written before independence, just right before independence. They need to get the courts up and running again. But people by the 1830s, 20s, 30s, 40s are rejecting this and saying New Jersey doesn't really have a constitution because the legislature can just go in and amend it whenever they want. And so you see this evolving sense that people want their states to have some kind of distinctiveness in how they view they view rights and safeguard liberties. And there's a lot of research just get the sense that there's a lot of research questions sitting out there on the table that are unanswered, and how we are trying to really capture what happened in 1776 and what it unleashes and inspires. And it's also, I think that work is also hopefully going to be suggestive of responses to lockstepping and to current interpretations of state constitutional texts and in litigation.
If I may, though, I love your story about New Jersey. I'm not sure that the pushback in the 1820s and 30s would suggest that they want to be distinctive. I think it says something more about how the evolving idea of what a constitution has changed.
That's right.
It's not until Massachusetts in 1780 has a referendum, which we actually know was a highly rigged and difficult process. It probably didn't actually pass, but it starts to give this idea that in order for a constitution to be legitimate, first of all, that it be written down at all is kind of a radical innovation, and then that it requires certain steps to be real. And so New Jersey's isn't legitimate. It says something, I think, about not necessarily the document itself, but more about the process by which Americans come to give it legitimacy. And I really enjoyed the earlier presentations about thinking about the relationship between state courts and the federal court, and the way that Americans are trying to use them in different ways, the relationship between them, and that the way that what that suggests about how we legitimate what we're doing, how we opportunistically maybe sometimes are going to a state constitution or going to a state court, or maybe not. Maybe it's not actually working in an anti-majoritarian format, or a state like Wisconsin or others are becoming.
I have a question, I guess, for Robinson and for Judge Sutton. How useful is this historical work in the work that you've done and the writing that you've done? You get these. We've talked about our work, and it can be difficult to see some of where the intersection. You can see some clear intersections, and there are probably more subtle ones. But where has that been important, and what's been most useful and provocative in how you've thought about these questions and written about them?
I'm happy to start. I mean, I don't have time to be an historian. I'm not an historian. I don't know what I'd do without Gordon Wood, Alison LaCroix, and the work of Jessica Robinson. I mean, it's really valuable. I did want to make just a couple quick follow-up points that I think the Quill Project, as you look at all these constitutional amendments or constitutional conventions or whatever it is that each state did after the colonies. But was super interesting to me about the territory experience was I don't think they were as interested in becoming a member of the United States as they were in becoming states. As territories, they were already part of the federal government, so they had that going for them. What they deeply objected to, and I thought was the motive of most territories becoming states, was writing their own laws, picking their own leaders, governors, judges, and legislators. And so what's amazing to me is how in the world that history ever led to lockstepping. It's completely bizarre.
Mm-hmm.
I mean, they were breaking from the national government with the president picking their governors, the president picking their judges, not having their own constitutions, in the same way the 13 colonies were breaking from Britain. It was the same dynamic. We don't want to be ruled from DC any more than we wanted to be ruled from London. The the thing I wanted to pick up on with Robinson's point, I do think gerrymandering does create problems with states being the best types of labs you would like. But no matter what the situation is, they still offer you a second shot. And the states should still be quite independent about their views about the right thing to do. No matter how much politics enters into it, all politics, as they say, are local. And so even if it's true that the states' labs is not as ideal as it could be with gerrymandering, that none of that changes the second shot point. Doesn't mean you're going to get it, but it still is a second shot. And that what's so surprising to me is lawyers are known for liking to win. Political scientists are known for wanting their side to be vindicated. There are two ways to have that happen. And it just astonishes me that in 2024, the average American lawyer just does not get that. And I can tell you as a judge, lawyers do not hesitate to bring lots of frivolous claims. That is not their problem. So why they won't pick a good claim is, to me, a very clear indication of the incredible gap in civics education in this country that even the law schools can't manage to correct.
So I think it's a testament to this panel that we really do have a sort of interdisciplinary approach here. First, to Judge Sutton's point, it's absolutely right.
Jeff, if I'm calling you Robinson, you better call me Jeff.
Thank you, Jeff. Litigants should take the second shot when it's available, and that applies outside of courts, state courts as well. Reformers who want to pass an amendment ought to look to the states as well. It requires, I think, a greater level of judiciousness now to know which states are more amenable, and which state courts, and also more so which state legislatures are actually amenable to amendments or to reinterpretation of doctrine, partly because the legislature simply are more polarized than they were when voting rights, for example, were a nonpartisan issue. This was a lot less fraught than it is now, similarly with abortion politics. So, my lesson isn't that one ought not take the second shot, but one ought to think carefully where to take it. To Professor Ronnie's point, so to what extent is history useful? Well, history is, of course, always useful. I'm a native Washingtonian. The District of Columbia has been fighting for statehood for some time. We, in 2016, wrote a constitution without calling a convention. And I wrote, in retrospect, a kind of incendiary op-ed in the Washington Post claiming that this constitution was illegitimate because we never held a convention. Even though I dearly want statehood for the District of Columbia, process matters exactly for the reason that it did in Tennessee. Tennessee gave the model for the District of Columbia for holding a convention and then applying for later passage of an admissions act, what we now call the Tennessee Plan. Advocates in Washington looked specifically to that first convention in Tennessee in 1792 as a model for our own constitution-making process, even if we failed the call to have an actual convention, something that I hope we will eventually do should we get the majorities in Congress to pass the D.C. Admissions Act.
Yeah, Jane Manners is joining us today too, and logged on. And there was just a observation made that so it's baffling why more lawyers are not trained to use their state constitutions in more creative and thoughtful ways. And wondering where you think this, Jane, where you think this field is from the standpoint of being a law professor, and what the big questions are in approaching their study of state constitutions, what the big questions are right now. I think you're muted.
Okay, there we go. I first got a sign saying the host will not let you unmute yourself.
I'm sorry.
So I apologize for being late to the conversation. I had to teach until 3. But I also apologize because I am now blanking on where I saw this, and it may actually have already been mentioned in this conversation, but I recently read a kind of kind of impassioned call for law schools to really teach state constitutional law for all of the reasons that Judge Sutton was just saying. State constitutions offer another, 2 bites at the apple. They have protections that are often far more robust than the protections you have in the US Constitution, but it is largely overlooked in law schools. And I'm hopeful that will change. I think I think law schools, for a variety of factors, are far more interested in kind of federalism and state constitutions than they have been for a long time. But there's always a period of catch up where you kind of recognize a need. We have to make sure that we do our duty to our students by teaching state constitutional law. And then you have to have the faculty to do that. It's a little bit more complicated because there are, 50 state constitutions and only 1 US Constitution. So finding the kind of faculty with that sort of expertise but I think, my sense as a law professor with a kind of curious eye to how this field is developing, I think that we are at a kind of more hopeful moment in terms of appetite and interest on the part of law schools for kind of encouraging future lawyers to think about state constitutions than we have been in quite some time.
Can you talk a little bit about your own work?
Yes. So I kind of came to my interest in state constitutions thoroughly with my historian's hat on. My kind of larger project these days focuses on officer accountability and the history of officer accountability. And I was trying to figure out for a piece that I wrote a few years ago, how state constitutions fashioned the offices, the tenures of officers in order to incentivize the right level of kind of responsiveness and independence from political interference. And I saw, when I looked through state constitutions, the kind of state constitutions that were written right after the revolution, and then all of the various changes that were made in state conventions, that states were getting extraordinarily creative in trying to set the right incentives for officers so that they could be both politically accountable to either the electorate or to their kind of superiors, but also politically independent so that they couldn't be interfered with. And state constitutions were trying all sorts of innovative ways to do that. So I became very interested in how states were solving the problem of officer accountability through these using kind of basically multiplying the number of tools in the toolkit that an institution builder has to encourage responsible behavior in office. So that's kind of where I entered my interest in state constitutions, and then I have follow-on interests from there.
But you approach that. Have you been trained as a historian? I mean, I know you're biased.
So I'm a JD and I have a PhD
exactly.
in American history. I have never been trained in state constitutions in particular. Forgive me, I don't even remember if my law school I don't think they offered any instruction in state constitutions when I was there, which is, kind of proving our point. But no, so I had no kind of methodological priors when I went into looking at state constitutions. I was just kind of curious to see what was going on. I mean, I should say I have some familiarity with the history of constitutional conventions. I think Jed Sugarman has a terrific book that talks a lot about the kind of constitutional conventions that took place in the 1840s, where you had this kind of populist wave that resulted in elected judges and a whole host of other kind of institutional tweaks. So I was kind of primed to look to state constitutions when I started my own research in a related field, because I knew that this was a site of real institutional innovation. But yeah, no official training.
Yeah,
could I make a comment, Brian?
Yeah, absolutely.
I was just going to make 2 quick points. The teaching thing is, I agree entirely, Professor Manners. It takes a while. These things take a while to get going. I actually think the teaching problem is probably at the high school level when we do civics, that we're not expanding that. The only federalism we teach is Jim Crow and Brown, and I get it, but we could broaden the lens a little bit more. The reason I think it's too early to make this incredibly provocative prediction, but it has happened with school funding, it has happened with religious liberties, it has happened with property rights, And the question is whether it's going to happen with abortion rights. And the very provocative possibility is that the losers in Dobbs won by losing, and that in 10 years we'll wake up and realize the states, mainly through state courts, but also state legislation, state constitutional amendments, did more for the cause than the federal courts ever would have or ever had in the past. And if that ends up being that story on an issue of such salience, no one's going to be worried about teaching state con law, because everybody cares about their issue. And if it turns out we flip the Jim Crow script so that in some areas at least the states are the better defenders of rights, that's just going to really change things. Because I still think we're living in a Jim Crow world in terms of history, that's how we think of states. And that's a very hard thing to undo because it was such a brutal chapter. So that's to me. But, school funding, it turns out, religious liberties, property rights were not sufficiently salient to educate people. Reproductive autonomy might be.
Any thoughts on this, Jessica or Robinson? Do you think, Jess, do you have a sense of where you're in a position where you do get to see some, you do get to see proposals or see responses to calls for papers? Is there an uptick in people interested in this in our field that you're noticing or aware of?
I first floated this idea of a conference on state constitutions and other forms of constitutionalism other than the federal constitution in the era of founding, and I was shocked at how thrilled people were. I mean, just like falling over themselves. And I should say I'm actually collaborating with Grace and with Nick. Yeah. So maybe we're all talking in a circle, although they're not here, unfortunately, today. But I think
Nick landed and just texted me, "How is it going?"
I think there's a lot of interest, and I think that maybe historians, I mean, I think historians are always thinking about the questions that it occurs to us to ask are very much inflected by what's happening around us. And Robinson, I'm also from Washington, D.C., so I wonder if there's actually not a particular niche of people who did not ever who don't have state representation, who don't have a state constitution themselves, people from DC who have their own investment in this question. But perhaps that is so. I think there's actually a lot of energy from my little corner of academia. I think there's a lot of energy in studying early state constitutions and the ways that they were founded and the conversations about who gets to do it and why. And I think, to Judge Sutton's earlier point about this interest, the way that reproductive rights may turn out to be the game changer in terms of how other people are thinking about state constitutions, I think that it comes back again to a question of when and where people's preferences can be articulated in ways that actually matter, and that where there's a statewide referendum that is not hampered by gerrymandering or other forms of kind of dampening the popular will, you can actually see people using the states and state law and state mechanisms to redress things that they don't have the opportunity to have their preferences listened to in other venues. So I think there's a lot of interest in states, just to keep repeating myself.
Yeah, and I think that's a good point, that there's the visibility of, we notice it among in our sources in our work, the visibility and salience of state constitutions certainly sees an uptick when there's a particular issue or there's friction that people encounter and there's something they want redressed by their state that they can't get, especially in the antebellum period, where there's just where there aren't federal issues, but there's something that the great tensions that drive historical work is that looking for moments when expectations and reality come head to head, and people decide to start, that they need to either replace or amend their state document for whatever reason, or they, decide to go impeach a state judge or something. I've been looking at the Addison, part of the Chase impeachment, looking at the Addison impeachment in Pennsylvania. Sort of the connections between how, again, like where people's experiences germinate from and are formed, they bring that onto a federal stage, and everything looks very different to them all of a sudden, right? Because they're coming out of different jurisdictions and get these really interesting conflicts. Any other thoughts on this?
So a final thought, this is a little off the top of my head. When I was in preschool, I had a pet frog, which I brought to a show and tell, and no one really cared about it except for one kid who had a pet frog as well. And doing state constitutions work is often like that. You're often the only person in the room. But I think it's a real testament to the success of this panel and of the field that's increasingly not the case, that more and more people really do seem to engage when you talk about state constitutions, that the salience is publicly increasing such that often this sort of work does not make you the odd person in the room. And so, I'm grateful that we have a space like this to do this kind of work.
Thank you. Judge Sutton, any final thoughts?
Well, as the federal judge, I'll say there's nothing like a frog to insulate you from the harms of a terrible federal decision. Occasionally we make mistakes, and it's nice to have a frog to what frogs turn into princes. Is that how the whole thing goes? Anyway, so I quite agree. There are more people out there. I'll give you one illustration of this. I could speak 150 days of the year if I accepted every invitation to talk about state constitutions. That's every other day. I mean, it's crazy. So that is a change from when I started doing this 20 years ago.
Well, I really appreciate everybody being able to give us one of those 150 days today, and to Jane and Jessica and Robinson here, and to our guest today. Really appreciate you joining us for this first seminar, and we'll be, as I've said, visit our the site that we have set up is stateconstitutionslab.org. We are looking to create a workshop that will meet regularly to consider works in progress. We'll meet probably like this during the day virtually, since this seems to be the way of the world now, to read work in different disciplines on all matters of state constitutional studies from all disciplines, and try to create a good community and working group around these subjects, these subjects and this topic moving forward. I'll also be putting there, and I'll send this out on the mailing list, but a call for proposals for what will be an essay collection to coincide with 2026 about the salience and history and use of state constitutions over the last 250 years. So keep an eye out for that and for more announcements. And thank you again to our guests and everybody who's joined us here today. We look forward to talking again soon, and we'll be in touch. Thank you so much.
Thanks for watching and listening. I hope you enjoyed this conversation. To learn more about the State Constitutions Lab, visit us at stateconstitutionslab.org. You can join our mailing list, see our call for papers, future projects, and meet our team. For the State Constitutions Lab, I am Brian Murphy. Thank you for joining us.